This is an application and appeal in the matter of Marlborough DP Limited and HMRC.
Yes, Mr. Firth.
My lord, my lady, I appear with Mr. Ben Blades for the appellant, and my learned friends, Mr. Dosh, Ms. Belgrano, Ms. Black, and Mr. Kelly appear for the respondents. There was an application, but I think the parties have managed to sort that out between themselves, if you've seen the correspondence and emails yesterday afternoon. So there's one document HMRC asked to be admitted, which was the Upper Tribunal's rejection of their own application to appeal, and we've said no objection to that. So, unless the court has anything to say that, I think that probably deals with the application.
No, we're content with that.
I'm grateful. In terms of the structure of our submissions, I intend to address the court on the Part 7A issue. Mr. Blades will address the court on the corporation tax deduction issue.
Thank you.
My submissions will be structured first by showing the court the relevant parts of the first tier tribunal decision and the upper tribunal decision. Second, introducing the legislation in Part 7A to show you the structure and how it fits together. Third, I intend to refer you to 5 cases which I suggest should guide or assist this court in its correct approach. And then I propose to take you through our submissions, our grounds of appeal as set out in our skeleton argument. I make it clear, as we have at each stage of this litigation, that we accept that this scheme did not work. You can see that at paragraph 6 of our skeleton. We accept that if the sums were not taxable as employment income, then there was no corporation tax deduction. If I may begin by just giving you a few headlines, I will develop these in due course, but they give a flavour of where our submissions are coming from. Our submission is that Part 7A is a broad test, but it's not an unlimited test. Asking, as the first tier tribunal did, whether employment is part of the reason for the payment or loan is a broad test. And we respectfully submit there's a potential danger of that being overlooked in the context of an appeal where HMRC are asking for an even broader test. But the basic starting point is the first tier tribunal did accept and apply a broad test. And we say, and I will show, or seek to show, that the first tier tribunal's test ties in with the context, background, and purpose in due course. And it's important, we say, to bear in mind that Part 7A is directed at avoidance of employment income tax. I pose the question rhetorically, how can you be avoiding employment income tax if employment is not part of the purpose of the payment? It's part of the reason for it. Reliance on the concept of tax avoidance presumes something that ought to be taxable as employment income. And we suggest that there is no such avoidance of employment tax where employment is not part of the reason. Instead, such payments are properly taxable, if they're taxable at all, under other provisions of the tax code. And that approach, which the FTT adopted, we say, has the significant benefit of significantly avoiding the double taxation that we submit the HMRC and the Upper Tribunal's test lead to. Because on those tests, you have a payment by a company which is taxable as a distribution in respect of shares. If there is a later charge by reference to something done, in this case by trustees, there is no mechanism to discharge or relieve the tax on the distribution. You have the payment by the company into the trust. That's a distribution in respect of shares. At some point later, it may be soon, it may be much later, and that's an important point. You don't know. The legislation doesn't take account of how long between the two events. At some point later, you have a relevant step that falls within Part 7A. You have, on the revenues case, tax under Part 7A. So you've had tax on the distribution on the way in, and at some point later you have a relevant step and you get tax again. There is no mechanism in the legislation, and in particular in Part 7A, to discharge or relieve either of those taxes. They both, on the face of it, subsist. And it is important, I submit, to bear in mind that whether and when and in what quantum you have a charge under Part 7A may well be uncertain as to timing and amount. And it's very difficult, applying any principle in the case law, to see how the possibility of an uncertain and unquantified tax charge under Part 7A in the future provides a basis for excluding an immediate charge on a distribution in respect of shares. It's very difficult to see how that could work. It's very different where you've got the same event at the same time and you say, well, one tax charge excludes the other. That makes sense. But here we've got sequential steps. We've got the payment by the company, one tax charge. Something happens in the trust. Could be immediately, could be much later. We have another tax charge. There is nothing that prevents both charges arising. So those are the headlines. If I may now take you through the FTT decision to show you the build-up. And we do have to go through, if we made the section on why this wasn't earnings from employment, because the FTT relies very heavily on its findings there in relation to its finding on Part 7A. So I will have to show you those parts in some detail as well. If we could turn up the FTT decision, please. It begins on page 152 of the core bundle, but the court may have it separately. At paragraph 9, please, on page 155, the FTT introduces its findings of fact. It talks about the evidence of Dr. Thomas, who was cross-examined, and they find that Dr. Thomas was a credible witness, and we've accepted his evidence except where stated to the contrary. Our opinion as regards the credibility was formed at the hearing and confirmed in our discussions taking place very shortly after the hearing. We know that Dr. Thomas was candid about the purpose and operation of the trust arrangement. And viewing the documents now, you can see they contained untruths, as HMRC put it. We comment further on the evidence he gave below. So Dr. Thomas, he gave evidence. He was, in the tribunal's words, he was candid about what had happened. He wasn't trying to pull the ball over the tribunal's eyes. He explained it fairly, and the tribunal was clearly accepting of his credibility. Paragraph 11 is the general background. So Dr. Thomas qualified as a dental surgeon in 1996, operated as a sole trader, and then became concerned about trading without limited liability and decided to form the Appellant. Paragraph 12, he heard about remuneration trust arrangements through a friend, a doctor, discussed with Mr. Freeman, put him in touch with a financial advisor. He also discussed with his father-in-law, a retired HMRC officer. He first used the arrangement when operating as a sole trader. Paragraph 14 onwards explains how the trust arrangement worked. I assume that the court is familiar with that from these documents. I don't propose to take you through the detail of it. It's as I've described in essence, there was a payment into the trust and a loan out of the trust to Dr. Thomas. And we accept that they were in short order in this case, we accept. If we could then turn to the tribunal's findings on the purpose of the scheme, that begins at paragraph 41 on page 163. Under the heading Purpose of the Scheme, Dr. Thomas agreed. So this is in cross-examination by mine and a friend. One main feature of the arrangement was to reduce the appellant's tax liabilities, and that it was also one of the objectives to take the monies contributed out into his hands tax-free. That was one of the things that appealed to him. In light of that, the only driver for deciding how much to be paid into the arrangement was to reduce the profits to nil for corporation tax purposes. That was how he quantified how much was to pay into the trust. And that's a significant point because this is the profits of the company. That's what's being quantified. That's what's being paid out by the company. And we'll see that the tribunal says, well, that's an indicator that this is in the nature of a distribution of respective shares because that's one feature. You can see the tribunal goes on to say, Dr. Thomas added, it would be the same as dividends if he'd gone down that route. In his view, a very similar arrangement. He plainly meant that if the trust arrangement had not been in place, the whole of the profit would have been paid out by way of dividends. And if that had happened, there would have been no question of Part 7A or employment tax, and that was accepted by HMRC in the first year tribunal. Subpoint 3, precisely the same sums would have been contributed to the trust whether he'd held 100% of the shares or 75% of the shares. And we note, as the tribunal will in a moment, that that relates to how much would have gone into the trust, not how much Dr. Thomas would have got out by way of loan. At 43, Mr. Ghosh suggested in his submissions on the basis of the evidence, Dr. Thomas accepted that he would have received 100% of the contributions as loans, even if there had been another shareholder such as his wife. We do not accept that conclusion can be drawn from the evidence. In cross-examination, the relevant questions were focused on whether if Dr. Thomas had not had all the shares, that would have made any difference to the sums contributed. Dr. Thomas was not asked if the shareholdings were different, he still would have received all the sums contributed by way of loan. At 44, the tribunal refers to various parts of the evidence on Dr. Thomas's understanding as to whether he get a loan, and then that's summarised in 45. We take from the above evidence, A, Dr. Thomas had been told it was part of the plan that getting the desired advantages to the trustee had to have the ability to refuse to make loans, but B, he had no reason to think in practice they would refuse loans, given that he knew the funds passed into the vehicle which he controlled. He could not have been in any real doubt. Any risk was highly theoretical, as to be meaningless. 48 begins a section on nature of the receipts, and if we can look at 49, I think there's a passage HMRC tried to place reliance upon, but we said it doesn't bear the weight or even the meaning they say. It was put to Dr. Thomas that the loans he received had nothing to do with him holding shares in MDPL. It was just a good way of extracting that money at tax-free. He said, that's what I was told, yes. We know that Dr. Thomas only agreed this is what he was told. He did not state that he thought the loans had nothing to do with his shareholding. 50, he agreed that neither he nor BW thought that the contributions were a dividend. 51, when it was put to Dr. Thomas that commercially he needed the loans because that was money otherwise would have gone to him as earnings, he said that if the money had not been in the trust, it would not have come as earnings, but as shareholder dividends. Put to him that before he incorporated, this was all the money that he was earning because of his expertise as a dentist. He said no, because I would have been earning off my associate and my hygienist. So it would have all been profit to the company or the business. Wouldn't have been just what I was doing. 53, I do not take from Dr. Thomas's evidence, as Mr. Ghosh suggested, that Dr. Thomas accepted the monies received by MDPL were all related to his role as director, given that he only agreed with this proposition when asked to put to one side the fact that MDPL employed others, such as the associate, dentist, and hygienist. Otherwise, he was clear that in his view, but for the arrangements, the profit would have been extracted as dividends, and those profits are generated by other persons' activities for MDPL, as well as his own, as accords with the evidence at 41.2. I think that's what I wanted to show you in terms of this section. We then move, please, to the first year tribunal's consideration of the earnings issue. And it will be useful in my submission to show you how the tribunal looked at the law and what it said about it, because it's common ground in the Upper Tribunal that the FTT got the law right on this issue, on the earnings issue. And the Upper Tribunal said it was a cogent explanation of the law. So if we may look, please, at paragraph 68, under the headings, are the relevant sums taxable as earnings? Overview of the dispute. The parties' submissions are outlined at 68. Subparagraph 1, the appellant considers the contributions/loans were not made as a reward for services as the director. There is nothing linking them in the required way with Dr. Thomas's role as such. Rather, the evidence demonstrates the sums are distributions paid in respect of shareholdings. It's notable in particular the sums reflect the entirety of the profits, and the clear evidence is that had they not used the trust, they would have been paid as dividends. HMRC view on the contrary, the payments must represent the fruits of Dr. Thomas's work for MDPL on the basis that A, MDPL was paid for the work that Dr. Thomas did as a dentist, solely because he was a director. So look there, HMRC are relying on the reason why the company was paid. They're looking at the source of the money to the company. B, there is no identifiable non-employment source for the payments, given they were not declared as dividends and not paid in respect of shareholders. If we can then skip forward, please, to paragraph 77. This is where the tribunal reminds itself on the law in relation to distributions. HMRC seem to say at times there can be a distribution for these purposes only in circumstances in which formal company law procedures are followed. And the First State Tribunal says that's not correct. And in particular, subparagraph 1, as set out by Lord Walker, and the leading authority, Progress Property Company. The theme running through the case is that the issue, whether there is an unlawful distribution, is a matter of substance, not form. The label attached to the transaction by the parties is not decisive. At 78, the FTT begins its consideration of the law on the meaning of earnings. It begins by referring to Lord Hodge in the Rangers case. And then subparagraph 1, under Schedule E, rules emoluments were required to be from employment. The Schedule E imposes tax on the remuneration which the employer pays to its employee in return for its services. The concept also underpins the concept of earnings in TEPA 2003. That which was an emolument in the prior legislation remains an emolument. 93, please. So this is begin at 92. The tribunal is now looking at a case called Kuna from the Court of Appeal in 2012, and it recites Lord Justice Mummery in that case said that the use of from in a fiscal context indicates as a matter of plain usage that there must be in actual fact be a relevant connection or link between the payments to the employees and their employment. At 50, Lord Justice Patton noted the court's task is to apply the statutory test to the fact and not to apply some other test based on a gloss, but he thought some gloss is inevitable because it is accepted that it's not good enough merely to show the payment was received as an employee would not have received if you were not an employee. Something more must be established. This has been expressed in terms of the difference between a causa sine qua non and a causa causans, but it does in any view require a sufficient causal link to be established between the payment and the employment. At 97, the First State Tribunal refers to Lord Justice Patton, saying that the process of evaluation requires the judge to make findings of fact based on the evidence as to the reasons and background to the payment, and then to apply a judgment as to whether the payment was from the employment rather than from something else. So the approach in relation to earnings is, well, we've got to make findings of fact as to the reasons and background for the payment, and then see whether the relevant test, the relevant threshold is met. And you'll note when you come to the Part 7A approach of the FTT took, there has to be part of the reason, and it's a similar type of analysis. You're looking at the reasons. The threshold could be different, but the basic underlying analysis of what are the reasons is similar. At 97, he considered at 56 the tribunal was obviously right to say that a payment can be from employment even though there are other reasons for it. He noted that in all the cases referred to, there are competing causes. In each case, the payments were motivated in part by a feeling of generosity. However, employment does not have to be the sole cause, but it does have to be sufficiently substantial as to characterize the payment as one from employment. And that's where the case law on earnings, general earnings, gets to. It has to be a sufficiently substantial cause to characterize it as from employment. And that's the from employment test. You can see in 98, if the employment is a substantial and equal cause of the payment, it becomes open to the judge to say that the statutory test is satisfied. Payment is then from the employment, even if it is substantially attributable to a non-employment cause. 99 begins the consideration of the Rangers case. In summary, in the second sentence, it says, HMRC also relied on the decision of Rangers, and in their view, the reasoning in that case applied equally here. However, as explained below, we agree with MDPL that in the circumstance of this case, the decision Rangers does not provide the answer to whether relevance are earnings. And we'll see why in a moment. Paragraph 102, please. So referring now again to Rangers in the Supreme Court. Lord Hodge noted at 23 it was clear from the documents made available as examples of the arrangements that the sums paid to the main trust and the sub-trust represented remuneration from employment. At 103, as Lord Hodge identified, at 36, the central issue was whether it was necessary that the employee himself or herself should receive at least be entitled to receive the remuneration in order for the reward to be taxable as emoluments. And the answer to that question was no. And we'll see that that's an important part of understanding the history of Part 7a. At 108, applying the legislation to the facts Lord Hodge held, 1, at 64, that the relevant provisions were and are drafted in deliberately wide terms to bring them within the charge to tax money paid as reward for an employee's work. So it's worth bearing in mind the charge of general earnings is already a broad charge. It is not a narrow charge. It's already a broad charge, and that's paragraph 64 of the Supreme Court in Ranges. At 109, we can see the point that the First Tier Tribunal has just explained in some detail as to why Ranges didn't provide the answer to the immediate case. It is plain, therefore, that there was no doubt in this case that the relevant sums constitute a reward for the relevant employee services. So in Ranges, no doubt that the money was a reward for services. The issue was whether the sums were prevented from being earnings because they were routed through the trust arrangements. The answer was they were not. As regards the different circumstances of this case, the decision tells us only that if the relevant sums constitute a reward for Dr. Thomas's services as director, it would be no bar to them being taxed as such they were paid through the remuneration trust arrangements. The decision does not mean, as HMRC seems to suggest, that sums are taxable as earnings simply because they were routed through such arrangements. And the point is quite clear. In Ranges, the footballers only had one capacity. They were employees. And there's no doubt that these sums were a reward for their employment. The argument was, and we'll see this, well, I didn't receive the money, the trust received it, so I can't be taxed on it. And the Supreme Court said, well, that's wrong. So the point is, it didn't address the causation issue because it didn't need to. Instead, it just asked, do you need to receive it or be entitled to receive it? Answer, no. And we'll see the Upper Tribunal agrees with that in a moment. Paragraph 110, you can see we're now turning to a case called PA Holdings. That's a Court of Appeal decision from, I think, 2010. And at 114, please, in passages on which both parties have placed reliance, 32 to 40, Lord Justice Moses said that the tribunal was correct that the relevant income was derived from the employee's employment. And at 3, he said, so this is subparagraph 3, please. He said at 39 that on that approach, the court should not be seduced by the form in which the payments, that is, dividends declared in respect of the shares in the company, reached employees. It should focus on the character of the receipt in the hands of the recipients. He noted at 40 that the tribunal had followed that approach in holding that the payments were emoluments, and they relied in particular on the facts that A, the purchase of shares in the relevant company, which were then awarded to the employers, was funded in full by PA, dividends, and full value were transferred at no cost. The intention was to motivate and encourage the employees. The payment represented a bonus. $115, please. Deals with this part deals with the interaction in that case between the charge to tax on dividends and the charge to tax on employment income, because in that case you've got the same payment or the same award being provided as a dividend, but also satisfying the test for employment income. What do you do there? Well, Lord Justice Moses says, as we'll see, well, the employment income charge takes precedence over or excludes the dividend charge. So we see at subparagraph 3 of paragraph 115, please. At 59, he said that whilst the tribunal and the Upper Tribunal hit the nail on the head, they failed to drive it in. They concluded that the payments were emoluments by having regard to all the circumstances of the case and by looking at the substance and purpose of the payments and not to the mere form In reaching their conclusion, they followed a long accepted traditional approach to the facts. That approach enabled them, within accepted limits, to look beyond the form, the mere machinery by which the intention to pay the bonuses was fulfilled. He concluded that once that conclusion had been reached, there was no room whatever for any further consideration of a different schedule. If the payments were emoluments in the hands of a taxpayer employee, they could not be dividends or distributions in their hands. Any other conclusion offends the basic principle expressed in Fry that if income falls within one schedule, it cannot be taxed under another. 61, the principles of Fry, and for that matter all the jurisprudence relating to the issue of whether payments are from employment, to which I've already referred, established that once they had concluded the payments were emoluments, the tribunal had exhausted the inquiry as to the character of the income which the statute obliged them to undertake. There was no room for any further inquiry, no room for asking whether the form of the payments came within the wide embrace of the definition of dividends or distributions. But that applies, as I've said, where you're dealing with the same payment or the same step. We can then see the decision on earnings in the present case beginning at paragraph 127, please. That's on page 188. For all the reasons set out below, 126, we have concluded the relevant sums do not constitute earnings. There's a summary of the test. So having been through the case law at some length, the FTT now summarizes it. Again, no dispute this was a correct summary of the law. The Upper Tribunal, it was found to be. To recap, it is plain from the case law that sums constitute earnings if they are paid as remuneration or reward in return for a person's services. The courts have consistently recognized that given the test is centered on why or in return for what the payment is made, establishing the purpose of an employer making the payment is key to assessing, as it was put in PA Holdings, its character in the hands of the recipient, looking at its substance and not its form. As summarized in Kuna, the courts have also recognized this may be a difficult, finely balanced exercise where there's more than one reason. As it was put at 52, in that case, a tribunal or court needs to be satisfied the payment is from employment rather than from a non-employment source. That involves evaluating the reasons and background to the payment and applying a judgment as to whether the payment was from employment rather than something else. Whilst employment does not have to be the sole cause, it does have to be sufficiently substantial. So that's correct. Now, 128, the tribunal sets up the position in the present case. It says, well, there's two possibilities here. The question is essentially whether the contributions made by MDPL, which enable those funds to pass into Dr. Thomas's hands as loans, are to be regarded as remuneration or reward for the provision of Dr. Thomas's services as director on the basis of the role as the reason why MDPL made the contribution, or a sufficiently substantial cause of the contributions for the test to be met, or two, whether MDPL made the contributions for a different reason, so that they have a non-employment source, the only identifiable other reason being they were made in respect of shares. 129, the difficulty is that in the circumstance of this case, there is little to tell us what the underlying purpose of the appellant had been in enabling the relevant sums to flow. In our view, however, such relevant evidence as there is, points to the conclusion the relevant sums were not paid to Dr. Thomas under the arrangements as a reward for his services as director, but rather constitute distributions made as a return on his shareholding. And then it notes a number of points in the subparagraph. So subparagraph 1, there was no contractual obligation to pay the sums as a reward for Dr. Thomas's services, and there is nothing in any of the documents or evidence to suggest that that was the reason for the extraction of funds. That's important. This is not a case like the Rangers case where you've got negotiations between an employer and employee, or anything like that, or any evidence. There was nothing in any of the documents to suggest that the reason for this was to do with his service. 2, the sums paid to Dr. Thomas comprise the totality of the profits after deduction of expenses and paid out sporadically. 3, the evidence was that had these profits not been routed through the arrangements, they would have been paid by way of dividend. 3A, it is well-known common practice for a sole owner and director of a company to organise matters such that they get a small salary and a substantial dividend, and that's how Dr. Thomas does it now. 4, we do not accept HMRC's view that Dr. Thomas's evidence is not relevant. In short, A, his evidence as the controlling mind of MDPL indicates that its purpose in putting in place the steps to extract the funds was to provide him with a return on his investment in its as a shareholder in the same way as if it formally declared a dividend. So that's the finding on reason. That's supporting part of it. It does not detract from this that Dr. Thomas and MDPL did not consider they were making a dividend or check. It was the relevant contributions were not unlawful distributions. 131, the tribunal deals with HMRC's submissions on this issue. Gown keeps getting stuck. HMRC rely on the fact, so they argue that A, MDPL received the income generated by its dental business because Dr. Thomas's role as a director. Again, look, HMRC are relying upon the reason why the company gets the profit, gets the money from its customers. So when the company provides dental services, HMRC is saying, well, the reason why the company gets money in return for those dental services is you, Dr. Thomas. They're not looking at the reasons why the company made the payments into the arrangement. B, the resulting profits represented the fruits of its labour, and C, the payments of them as contributions to the trust were not declared as dividends and were not related to his shares. We see a number of difficulties in this analysis. First, the HMRC's analysis of the facts does not chime with the distinction in corporate law between the company as a legal person and the individual who manages it. And basically, the tribunal goes on to say, well, of course the company acts through Dr. Thomas because it can't do anything else. Two, the fact that the relevant sums were paid through, as HMRC put it, untruthful RT arrangements, which were implemented only for tax avoidance purposes, does not of itself, as HMRC seems to suggest, provide evidence the relevant sums are a reward for Dr. Thomas's services. Perhaps I just ask you to read A to C of that one rather. And that point is emphasised and developed again in subparagraph 3C on page 191, please. It does not necessarily follow from this that Dr. Thomas and MDPL's purpose was not to provide Dr. Thomas with a return on investment as a shareholder, and was, so HMRC asserts, to provide a reward for services. Rather, it simply A, demonstrates that Dr. Thomas thought that through using a particular legal form of profit extraction he could achieve a desirable tax result, and B, leaves open the question of whether Dr. Thomas's underlying purpose, or the appellant's underlying purpose in paying the relevant sums through the ineffective structure was to reward Dr. Thomas or provide a return on its investment. For the reasons already set out, Dr. Thomas did not accept it. Mr. Gersh at times seemed to suggest that A, he would receive the same sums through the RFT even if he had not been the sole shareholder, and B, the relevant sums were not paid in respect of his shares. 5. As a matter of legal analysis, we do not consider HMRC's approach as correct, even if all MDPL's profits can be regarded as the fruits of Dr. Thomas's labour. A, HMRC assert that the result which their analysis would produce is not radical because it's based on particular facts. However, they not pointed to any material factor indicating the relevant sums are sufficiently linked with Dr. Thomas's role as director. That's significant. On the one hand, you've got the various points the tribunal makes. On the other hand, you've got no material factor HMRC have to point you to say, well, this is linked to your role as a director. Yeah. 192 in Roman 1 at the top of the page. Sorry, I'm reading a bit before it. In the absence of the identification of any other reason, HMRC's stance comes down to a proposition along the lines that 1. Income profits arising to a corporate owner of a business, which are in part generated by the activities of its sole shareholder and director, are necessarily linked in their entirety to that individual's role as a director and her employee. B, unless paid by way of formal dividend, the extraction of those sums constitute earnings. In other words, HMRC stands to mount in fact to a proposition that in those circumstances there is a presumption, or a default position, the company's purpose is to reward him for his role. And B, the tribunal rejects that, says out of kilter, the case law, not supported by ranges, and Roman 3 in subparagraph 5, the proposition that the formal declaration of the dividend breaks the link or connection with the employment, which in HMRC's view otherwise exists, is implicit in their submissions on this issue. However, such a proposition is unsustainable for the reasons already set out. And that was an important point, because HMRC accepted that if a dividend had been declared, it wouldn't be taxable as employment income. But the point you see in PA Holdings is that the mechanism doesn't matter. If it is a reward for service, paying it through a dividend doesn't stop it being a reward for service. It's still taxable as employment. So that must mean that in the ordinary case of a dividend, it isn't inherently, there's no presumption it's a reward for services, because the dividend mechanism will not break that link. There is that link, it's not broken by using a dividend. It does not exist in the first place. Not what the tribunal is saying here. So the tribunal acknowledged that there wasn't a great deal of evidence on this, but it did its best with the evidence it did have. It noted, as we've seen, that there was nothing in any of the documents to support employment being the reason, or a part of the reason. It noted that there was no material fact that HMRC were able to point to that linked it to employment. And therefore it concluded, reliant on the various factors you see, that the overall conclusion is this is in respect of shares. And that conclusion, we say now, is solid. It was challenged in the Upper Tribunal. That challenge failed, and we say it's now solid in this court. Now we turn, please, to the Part 7A aspect of the FTT judgment. That begins at 132, where the legislation is set out. 135 summarises HMRC's position, which is in essence, it's a broad test. And you can see at 135 subparagraph 2, HMRC essentially gave the same reasons for reviewing the loans as made in connection with Dr. Thomas's employment with MDPL as they gave in support of their view the relevant sums constitute earnings. Again, they emphasised the monies were received by MDPL, so received by the company, not paid by the company, received by the company due to Dr. Thomas's work as a dentist and director, and the fruits of those labour were channeled to him through the scheme. They said that whilst declaring and paying a dividend would have severed the connection, contributing this money to the trust as part of a tax avoidance scheme did not do so. My submissions are set at 136. And you can see at 1A, we accepted. The connection test is cast in deliberately broad terms. But there is a limit. The tribunal must examine the surrounding words in context to determine the required degree of connection. And we said at B, in that approach, it's plain that the intended type of connection is that A's employment is part of the reason for the reward, recognition, or loan. I'm going to develop these propositions later, so I won't linger on these points. C, for the reasons already given, not part of the reason. And then it develops my other points at 2, 3, and 4. I'm going to develop those again later, so I won't trouble with you. Now, 137, having set out the state of play, the tribunal says we agree with the appellant's view that reading 554A1C in context, for there to be a connection of the required kind, the employment must be part of the reason for the reward, recognition, or loan. On that basis, the assessment of whether it is reasonable to suppose that in essence the arrangements were, so far as it relates to Dr. Thomas, the means of providing or are not otherwise concerned with providing loans in connection with Dr. Thomas's services requires essentially the same analysis as set out above. So looking at the reasons, that's what it's saying there, and the Upper Tribunal accepted that. It's not saying it's the same test, it's saying you're looking at the reasons in both cases. You're looking at the reasons for the payment, for the loan, and assessing whether employment is part of the reasons. We know in relation to general earnings charge, it has to be a sufficiently substantial reason. But here the tribunal says it just has to be part of the reason. So it accepts the submission, it is a broad test. but that broad test is a part of the reason. And that's what I wanted to
Paragraph 137 was what the Upper Tribunal said was very compressed, didn't it? I mean, it is quite difficult to get out of 137 the full sense of the reasoning of how the words "in connection with," which you do see in the Part 7a language, don't come up in the earlier point about whether it's employment, income at all. You're looking at a set of words.
Well, you saw it, and this is why I did take some time. You saw it several points, and in particular in relation to Kuna, that when looking at whether something's from employment, the courts say, well, you need to look at the reasons, the background to, and the reasons for the payment. And the tribunal reminds itself at the outset, I think it's paragraph 127, what I need to do now to decide whether it's from employment is to look at the background and reasons for the payment. It then carries out that analysis and that evaluation of the evidence and concludes, well, the reasons for this payment is that it's in respect of shares, and HMRC haven't pointed to any material factor showing it's the reason is employment. So it reaches that conclusion, and that then carries forward, because if you've already carried out an assessment and evaluation of the reasons and background to the payment in relation to earnings, you don't need to do the same task and reach the same conclusion on the reasons and background to the payment under Part 7a, if that's the right test. I mean, we'll come to whether it is the right test, but there's actually no challenge to the FTT's decision that if that is the right test, it wasn't met. That wasn't part of the Upper Tribunal decision. Sorry, appeal. That isn't part of this hearing. So if that is the right test, there's no challenge to the FTT's conclusion it wasn't met. The challenge is, well, is that the right
Whether
test?
it is the right conclusion.
Yeah.
So does it follow on that submission that the critical question is the first sentence of paragraph 137 right or wrong in law?
Certainly, that's a very important question. That's ground one.
Yes.
Because the Upper Tribunal says that's wrong in law.
Yes.
Says it doesn't have to be part of
Yes.
the reason.
Yes. And,
So,
you say it's right in law.
I say it's right in law, and I have then grounds 2, 3, and 4, which lead to the same conclusion. But
Forgive me, Mr. Firth. All I meant was, in order for us to understand paragraph 137, is it your submission that if they got the test right in the first sentence,
yes,
there is no challenge to everything else they then said?
correct. Yes,
That's all I wanted to know.
yes. And the Upper Tribunal said, no, it's the wrong test, and I'm going to be submitting it's the right test. Turning, if we may, then to the Upper Tribunal decision, that begins on page 72 of the core bundle. We can skip through to paragraph 64, please. We can, and this is page 87. That's where the discussion begins in relation to the general earnings.
Yes.
And just to confirm what I'd said earlier, 65, it was common ground that the FTT had set out the correct legal test regarding whether a payment was from employment, see in particular 127. So that's what I meant when I said no challenge. That common ground, that was the correct test.
Yes.
At 70, in fact, the tribunal goes further. Argued the FTT analysed the law in meticulous and commendable detail. There was no misunderstanding of the correct legal principles in relation to the test for determining whether payments were from employment. We did not understand the FTT's analysis of relevant principles to be in dispute or was contested in the Upper Tribunal, but not contested in this court, the application. 71, the essential question in this appeal was the source. And so the source, was it the employment or was it the shareholding? 112 makes a point I've already made in relation to ranges, so it agrees with the FTT that ranges doesn't actually tell you the answer to the from employment question, it just tells you if it is from employment. So,
Sorry, where are you now?
sorry, paragraph 112 on page 99.
Oh, sorry.
Apologies, I've had it.
Yes, thank you.
We also reject HMRC's case that the FTT misunderstood or misapplied ranges. Mr. Gersh referred to ranges as a case which applied the redirection of earnings principle. It is true that where an employer requires that his earnings or her earnings are not paid to the employee but paid to someone else, the character and source of the payment does not change, the payment remains earnings. The point of the ranges case was whether the fact the employer was not legally entitled changed the character and taxability. None of the employees, the footballers in the ranges case, was a shareholder. The only capacity in which the payment was made or redirected was in their relation to their employment as employees of Rangers. Ranges is therefore not authority in relation to the source of the payment, but rather an authority in relation to the taxability of a payment made by reason of employment, but which is diverted. So that's the point I made before. I don't think I need to take it further at this stage. At 118, please. This is dealing with Mr. Ghosh's submissions. Mr. Ghosh's submission that the payments by MDPL to the trust represented the fruits of Dr. Thomas's labour and the labours of other employees in the dental practice does not lead to the conclusion that payments by MDPL constitute earnings on general principles. The source of the income arising to the payer does not mean that the payments made by the payer have the same character. For example, if a company with a sole director shareholder earns a rental income, the onward payment of the profits arising from that activity would not usually be regarded as rental income. There's a rejection of HMRC's argument, well, let's look at why the money arises to the company to determine the character of the onward payment. 119. And I mention this because there does seem to be a tension we respectfully submit between this part of the reasoning and the paragraph 150, which we'll come to later, but I ask the court to bear that in mind. And 119, third, the fact that the contributions were authorised by Dr. Thomas acting as a director cannot, in our view, impart the character of the employment income to those payments. The company can only act by the agency, either its directors or by resolution at general meeting. As Mr. Firth observed, the question is not who decided to make the payments, but why was the payment made. To suggest that a payment by a company which is authorised by its director imparts that payment with the character of employment income seems far-fetched. It would be a strange conclusion, which of itself suggests the proposition is incorrect. We then please turn, so you can see at 122, the Upper Tribunal begins its consideration of Part 7A. And at 135, well, at 133, just to give some context, so that they're now considering my arguments as to the correct test. And you'll have seen from my skeleton, part of our argument is we'll look at this. 134, they refer to an Upper Tribunal decision, and 135, they say Mr. Firth placed emphasis on the words to reward employees in the explanatory notes, arguing that the purpose was to address arrangements which were intended to reward employees, not to include arrangements where the connection to employment was indirect or peripheral. 136, we derive little assistance from the explanatory notes in this case. It's clear from those notes that Part 7A is an anti-avoidance provision, but Parliament's intention is concerning the meaning of the phrase in connection with is best discerned from the statutory words in the context. They turn to that. I mean, I'm going to come back to that, but my respectful submission is you can get more from the background material than the Upper Tribunal did in terms of identifying the type of connection we're interested in. And then setting out the various arguments, and we see the Upper Tribunal's conclusions beginning at 143.
Yes.
The first point to note, it's an objective test. Second, it's clear that this Section 554A and its related provisions are drafted in expansive terms intended to catch a wide range of arrangements, often involving third parties. That's a slightly strange proposition because it's always involving third parties. I mean, third parties has a definition, but it is always third parties. Whereby benefits, to use a convenient non-statutory term, are provided in connection with employment. I emphasise the section was intended to counteract schemes such as ranges, where HMRC had lost. Even if that is so, it seems that we must construe and apply Part 7 in accordance with its terms. We cannot limit its application to particular schemes. Let me be clear, we're not asking this court, we never asked the first-tier tribunal to limit this to particular schemes. Our point on this, as I'll come to, is that when you look at the type of arrangement that forms the background, that helps you identify what type of connection Parliament had in mind when it talks about in connection with. So it's certainly not limited to particular schemes, but those schemes and what Parliament had in mind are something to take into account when you're deciding what type of connection Parliament had in mind. I'll develop that later. At 145, third, also clear that Parliament used the phrase in connection with in preference to the time-honoured phrase of from employment or by reason of employment. It seems to us that Parliament's intention was plainly to give 554A a wider scope than the tax charge on general earnings. It follows therefore that a loan may be provided in connection with employment even though it's not from employment. An example, payment by an employer to an employee will not be treated as earnings merely because the employee would not have received the payment but for the fact he was an employee or she was an employee, but rather it must be a reward for services. Given the difference in language, which we see as significant, we would be minded to accept, without deciding, that such a payment, i.e. one which would not have been received but for, might be capable of being regarded as connected with the employment. I will come back to that later. 146 cannot be given a limitless meaning, as the heading to Part 7a itself states, it is to tax as employment income payments provided through third parties. There has to be a relatively strong and direct nexus between the employment and the contributional loans. Do not think Parliament's intention was to catch loans when the relationship with merely incidental or peripheral. We accept Mr. First's submission's statutory emphasis on the essence of the arrangements, and we'll see that in a moment. Reinforces this. We therefore consider, to use the language of the Court of Appeal in London Luton, there must be a strong and close nexus. 147 is the point my lord's already referred to, that the FTT's reasoning in 137 is compressed. However, in our view, the FTT did not state, as HMRC contended, that the test contained in 554A was the same as in the general earnings charge. What the FTT said was that the employment must be part of the reason for reward. When the FTT then stated that 554A issue required essentially the same analysis as that in relation to general earnings, we consider it was intending to indicate that it to look at the gain of the various facts and circumstances which it took into account in determining whether the payments constituted general earnings, but applying the part of the reason test. So compressed, but not making the error of saying it's exactly the same test. But then the error, 148, or the alleged error, we say it's not there. The FTT erred in law and stated in the test as being the employment had to be part of the reason for the reward. That is not the statutory test. The words used involve a test of connection, not causation. As we have said, we consider there must be a strong and direct connection. 554A12 provides all relevant circumstances to be taken into account. We consider this reinforces the need to identify which, if any, of the various facts constitute the sufficiently close connection. At 149, they say, well, the fact that Dr. Thomas signed the resolutions as a director is not enough. You can see in the fourth line up, a company can only act through the agency of its directors and employees unless it acts in a general meeting. We consider that resolving to make the contribution and requesting the loan were not sufficiently closely linked with Dr. Thomas's directorship to engage 554A. And then we have the crux of the matter. Having said there's an error in the FTT decision, it's quite compressed. We then have a very compressed, in my respectful submission, paragraph 150, applying its own test of strong and direct connection. And you can see that at 150. The profits of MDPL paid as contributions to the trust and then on to Dr. Thomas reflected the profits of the dental practice carried on by the company. Dr. Thomas was actively engaged in the practice as a dentist and was assisted by a hygienist and associate dentist. At all material times, Dr. Thomas was the sole director of the company and therefore the guiding mind of the company, solely responsible for the conduct and direction of its business from which the profits were derived. In our view, this is sufficiently direct and close connection with the directorship to ensure that 554A applied. We are satisfied that treating the profits of MDPL contributed to the trust and then to Dr. Thomas as connected with its directorship accurately reflects the essence of the arrangement. So that is very compressed. I mean, we've got a test. It's actually a test that the Upper Tribunal derived itself. It's not a test that either party submitted. Should be the test in the hearing. Well, I submitted it should be the part of the reason test. HMRC asked for a broader test. The Upper Tribunal develops that test by reference to London Luton. It applies at 150, and you'll see from my skeleton I've got a number of respectful criticisms of that particular paragraph, which I'll come back to. As I said at the very beginning, Mr. Blades is going to address you on the corporation tax issue. But if I may just show you a couple of passages, because we say that they are material when you're considering the correctness of the Upper Tribunal's own conclusion. So if I could ask you please to turn forward to page 111. It's paragraph 169 and 171. This is the Upper Tribunal explaining its reasoning for why there should be no corporation tax deduction. At 169, they say, we have no doubt that Mr. Woodman, who is a member in the FTT, Mr. Woodman's view that that the contributions were non-deductible was correct. On Dr. Thomas's own evidence, the contributions were made in such amounts as were necessary to reduce the taxable profit of MDPL to nil. The twin objectives of the BW scheme adopted by the MDPL and pursued by Dr. Thomas were to empty MDPL of profit and to advance that profit to Dr. Thomas by way of non-taxable loans. There was no intention or purpose to benefit the trade. And then at 171, instead, disregarding the untrue reasons given in the resolutions to the contributions, the intention of the company in making the contributions was to empty the company of profits in order to fund a tax-free benefit to Dr. Thomas. There was no trading purpose and no benefit to the company's trade. And so we say that those findings make it very difficult, and we say impossible, to find that the essence of this arrangement involved the making of loans with on the tribunal's view, strong and direct connection to employment. It's got no part of the essence. But I'll develop that again later. I just wanted to show you it now in context. If I may now show you, please, Part 7A, the legislation.
Yes.
That's in your authorities bundle. And it begins on page 9. You'll have seen this from both parties' skeleton arguments. This is the gateway to the Part 7A charge in 554A, subsection 1. Chapter 2 applies. We'll come to Chapter 2 later to see what Chapter 2 does, but in essence it applies a tax charge to the relevant step. Chapter 2 applies if A, a person is an employee, or former or prospective employee of another person, B. B, there is an arrangement to which A is a party who otherwise covers or relates to A. And to be clear, there's no challenge to A and B in this case. We're not looking at the substance of those provisions. They weren't met. And then C, it is reasonable to suppose that in essence, the relevant arrangements, or the relevant arrangements so far as it covers or relates to A, is wholly or partly a means of providing, is otherwise concerned, wholly or partly, with the provision of rewards or recognition or loans in connection with A's employment, or former or prospective employment with B. So that's where a lot of the debate before you centres, that particular phrase. D, a relevant step is taken by a relevant third person. And that's what I meant. It's always has to involve a third person. E, reasonable to suppose that the relevant step is taken in pursuance of the arrangement, or there is some other connection, direct or indirect, between the relevant step and the relevant arrangement. The legislation then helpfully tries to guide us through what comes later. So subsection 2 tells us that we can find the meaning of relevant step. And to be clear, that is the thing to which the tax charge applies to, is the relevant step. So you have the payments into, in this case, a trust, and then you have relevant steps taken by a third party. And there doesn't even need to be payments in necessarily. That's not necessarily what's required. What is required is a relevant step taken by a third person as part of a scheme that satisfies C. If I may just draw your attention, please, to 7, subsection 7. Relevant third person means A, acting as trustee, B, acting as trustee, or any other person other than A or B. So that simply means it includes the employer and the employee if they're acting in a different capacity as a trustee. Subsection 12, please, over the page. For the purpose of subsections 1C, which is us, and E in particular, all relevant circumstances are to be taken into account in order to get to the essence of the matter. And you'll have seen one of my submissions that this legislation twice forces home the need to get to the essence of the matter. You can see that in 1C and you can see it in subsection 12. So now we need to know...
Can I just pause on that? 'Cause it
Yes.
seems to me those are really important words. Aren't they saying that you've got to look at substance over form, and what you're really focusing on is the essence of whether the loan in this case is connected with the employment. In other words, whether the employment has a connection with the thing that's being done below.
In connection with, I will submit that connected with could be broader than in connection with, but I agree with my lady's proposition. Yes, it's forcing home the need to look at the substance, to just ignore the irrelevant and the
Marginal,
dispensable.
all that,
Yeah, so if you've got a connection with employment, but it's not part of the essence, if it's dispensable, then you can ignore that. But you need to get to the essence. Right, I agree with that.
So I mean, again, it's a layman's language, but is this statute saying to you what you really need to do is objectively look at these arrangements and ask yourself if the thing that was being done, the loan in this case, was in connection with the employment? Was that the essence of these arrangements?
Yes. And what were was that what the arrangements were a means of doing? So there's the various steps which my grounds of appeal go through. But yes, we've got section 1C, which has got several different concepts in it. But overall, yes, it's getting to the essence, the substance. Disregard the peripheral, the things that don't make it what it is. Well, yes, I agree with that. But we've still got to then consider what in connection with itself.
Oh, sure, it doesn't answer the question, but
Yes.
it poses the judgment. It's just a way of looking at it that poses the question which we have to reach a judgment on.
Yes.
But it may be that broad and narrow isn't necessarily the right way of looking at this piece of statute. I don't know, and we'll need to hear all your submissions.
Well, I would agree with that. I mean, we don't offer it because it's broad. We offer it because it's supported by the context and purpose. We just guard against the submission that might be made against me that, well, your test is very narrow and Parliament can't have intended a narrow test. So I'm not offering it because it's a broad test. I'm offering it because the reasons I'll submit it fits with the context, purpose, and mischief. We then need to know, well, what is a relevant step? And this is important, obviously, in terms of the fundamental application of the code, but also when you're considering questions like double taxation, because the code attaches the tax to the relevant steps. So we need to see what are the relevant steps. And the first step we see on page 78, 554B. Earmarking. This is a novel concept in tax law, that we've got a person takes a step within this section if a sum of money or asset held by or on behalf of a person is earmarked, however informally, with a view to a later relevant step being taken by P or any other person in relation to that sum of money or asset or any money or assets which may arise derived from it. And so to give an example, I'm never saying these are exhaustive, but to give an example, if money goes into a trust and the trustees, they could use set up a sub-trust, or they could do it less formally, but they say, well, that money there, we're not going to give it to Mr. or Mrs. A now, but it's for them. If you can prove that, then you've got an earmarking within the scope of 554B, because the later relevant step, the actual payment or the actual loan, would be a relevant step, but you've earmarked it for it. That's earmarking. Over the page at 554C, we've got a traditional possible idea of a relevant step. You've got a person takes a step within this section if you pay a sum to a relevant person, transfer an asset to a relevant person, take a step by virtue of which a relevant person acquires an asset, make available a sum that permits its use as security, or grants a lease. So we've got a broad approach here to what can amount to a relevant step. And if we skip forward, and we'll have to skip back in a moment, if we skip forward please to page 120, 59 of your bundle. I apologise, there's 2 page numbers on each page, which is a bit confusing. It's page 59 of the bundle, so it's red 59, the far bottom right. This is interpretation, and in subsection 7, we can see that references to the payment of a sum of money include, in particular, references to the payment of a sum of money by way of loan. At 554D, we've got another relevant step, making assets available. I don't think I need to trouble you with the detail of that. At 554E on page 16.
1-6.
Yeah, 1-6. We've got exclusions, steps under certain schemes. And I'm not going to take you through each of these because there's a lot of them. But these are carve-outs. You can see this first one's concerned with employee share schemes. The one I'm going to show you, if I may, is 554F, which is on page 1919, because HMRC, I think, rely upon this. It says exclusions, commercial transactions. It says 1, Chapter 2 does not apply by reason of a relevant step, which is a payment of a sum of money by way of loan if the loan is a loan on ordinary commercial terms within the meaning of section 176, ignoring conditions B and C, and there is no connection with tax avoidance. Now, I handed up before the hearing, because it's not in the bundle, section 176. It's a small piece of paper stapled together. I'm hoping it's on the desk in front of me.
So sorry, I need to catch up with you a little bit today. So 554F sub 2.
Sorry, no, sub 1.
Sub 1.
Chapter 2 does not apply.
Fine, okay, I've marked the wrong bit up. So basically, it takes out of account sort of ordinary loans.
Well, no, my lady, that's the point I'm making. So 1A, so these are the conditions. The loan is a loan on ordinary commercial terms within the meaning of 176, and that's why I've handed up 176. So you can see it's actually banks, really. You have to be carrying on a lending business to satisfy this. So
But that tells you something about the limits of in connection with, doesn't it?
I'm not sure it does, my lady. I mean, what it does, it tells you that Parliament didn't want to catch a situation where, for example, an employer makes an arrangement with a bank for the bank to provide loans on particular terms to employees, because then you could say, well, there's a connection with employment because you, the employer, are arranging this for the benefit of your employees. If you can satisfy the very strict terms of 554F, then that's out.
But why would you need, forgive me, interrupting, why would you need this carve-out? Unless otherwise Parliament thought the loan by the bank could be caught.
Well, it certainly could. If the employer enters into an arrangement with a bank to provide favourable loans to an employee, you would, even on my test, I would say, well, part of the reason why that loan is made is because of your employment, because your employers had an arrangement with a bank for it to provide particular loan terms to its employees. Therefore, it is in connection with your employment. Parliament is saying, well, in strictly confined situations, we will not treat that as within Part 7A. So it doesn't argue for or against my test. But the point I want to make is that it's not the broad carve-out for ordinary commercial transactions that it might appear without looking at 176. So you can see in 176, subsection 2, in this section, a loan on ordinary commercial terms means a loan made by a person, the lender, in the ordinary course of a business carried on by the lender, which includes the lending of money, the supplying of goods or services on credit in relation to which conditions A, B, and C are met, or we can forget B and C. Condition A is met if at the time the loan was made, comparable loans were available to all those who might be expected to avail them. A substantial proportion of loans made by the lender are made to members of the public. You can see it's very tightly confined. It's basically thinking of banks and financial institutions as the third party making the loans to the employer.
Does it need to be that? Is it for clarification? Because part of the 554F1B says there is no connection between the relevant step and a tax avoidance arrangement. So that would knock you out anyway. You wouldn't be in 554A, would you? Because that's all about arrangements which are connected.
Well, connection with tax avoidance is not one of the conditions in 554A.
Okay, yeah, okay.
So this is saying that if the employer, for example, makes an arrangement with a bank to have loans made to employees, and the bank satisfies those various terms in relation to those loans, then you can fall outside Part 7A. That's what it's saying. It's not a broad exclusion for ordinary commercial transactions. We then turn, please, to Chapter 2. If you remember, the beginning of 554A says Chapter 2 applies where, and then it's got a number of conditions. So we need to look at now at Chapter 2. That's on, you can see the heading on page 61 at the very bottom. Chapter 2, treatment of relevant step for income tax purposes. If we move them forward, please, to 63. 554Z2, value of the relevant step to count as employment income. 1. If this chapter applies by reason of a relevant step, the value of the relevant step counts as employment income. And then 2, if the relevant step, so it's focusing on the relevant step. If that relevant step gives rise to an amount which, apart from this subsection, will be treated as earnings under a provision of the Benefits Code, or any income of A would be dealt with under Toya 2005, Part 4, Chapter 3, then subsection 1 applies instead of that provision. So that's giving priority in respect of duplicate charges on the relevant step. So, for example, where Part 7A applies to a loan, you don't also have the tax charge under the Benefits Code on the interest benefit. So if you've got a loan that's below official rate of interest, normally you would say, well, you not pay 2.5%, so we treat the 2.5% as a benefit, you pay tax on the 2.5%. That's the ordinary way of dealing with an employment-related loan under the Benefits Code. This is saying, well, if we've taxed the loan, the whole amount of the loan under the Part 7A, we're not going to charge you under the Benefits Code as well. That's what it's doing, excluding duplicate tax charges on the relevant step. It does not exclude a situation where a payment into a trust was a distribution in respect of shares, taxable as such, and then the trustees do something which amounts to a relevant step. It doesn't deal with that situation. You'll have seen that 554Z2 says it's the value of the relevant step that counts as employment income. We need to go to 554Z3 to see what that amount is. That's on page 64. If the relevant step involves a sum of money, the value is the sum of money. And we can see yes, sorry. So if there is a loan, then it's the amount of the loan. It's not any sort of measure of the benefit of the loan. It's just the sum that it's loaned out, and that's the intention of the legislation.
Sorry, where do we see that?
That is subsection 1.
Well, if the relevant step involves a sum of money, its value is
Yes,
the
and
amount
you
of the sum.
remember that
Yes.
section 554Z says a payment includes a loan. So here,
I see.
and this is not controversial, this is how it works.
Yeah.
If it's a loan, it's the full amount of the loan, and you don't get any relief if you pay back the loan. That's a feature of the legislation. So it is, well, we say essentially treats a loan in the same way as an outright payment, because you get taxed on the full amount of the loan. There's no relief or repayment of tax if the loan is repaid. You just get taxed up front. So there's an equivalence in terms of the amount of tax between an outright payment and a loan. 554Z4 deals with residence issues, which we don't need to concern ourselves with. And 554Z5 on page 69, please. There's an overlap with earlier relevant step. And so when I go through each of these provisions dealing with potential double taxation, my point will be it doesn't cover the situation I've identified. And so we've seen that there's a provision that deals with a situation where the relevant step gives rise to tax under 2 charges, Part 7A and something else. The other charge is excluded. This deals with a situation where one relevant step is followed by another relevant step. So, for example, an obvious one, earmarking. If you earmark assets for a person, that gets a relevant step. Then actually giving that money to the person would also be a relevant step. What this does is it takes away the second charge.
Mm-hmm.
You can see that in subsection 1. This section applies if there's an overlap between a sum of money, which is the subject of a relevant step, and the sum of money, which was the subject of an earlier relevant step. The value of the second relevant step is reduced, but not below nil, by the extent of the overlap, essentially. So that's dealing with two relevant steps overlapping. It's not our case. We then see in Z6 on page 71 this section applies if the relevant step gives rise to relevant earnings from the employment which are in accordance with section 16 taxable and which are, sorry. Oh yeah, so this is where if the relevant step also gives rise to relevant earnings, then you can see in subsection 2, the value of the relevant step is reduced by the amount of the relevant earnings. So this, if the relevant step itself gives rise to earnings from employment, then you don't have a Part 7A charge. It's giving priority there to the general earnings charge. But again, it's all by reference to, well, the relevant step here is given rise to 2 charges. We're going to exclude one of them. In this case, it's the Part 7A charge. The final provision I wanted to show you is section Z13 on page 88, please.
Sorry,
Z13, 1-3 on page 88, please. So subsection 1, this section applies if, after the relevant step is taken, another event occurs, other than by virtue of this chapter, chapters 2 to 5 of Part 7 or Part 9, the late event would give rise to a liability for income tax of A or any other person on amount, and it is just unreasonable for this section to apply in order to avoid a double charge. So far as it is just unreasonable in order to avoid a double charge, there is no liability to income tax on the later amount. So this is where you have a relevant step and then something happens later that gives rise to another charge. Then there's a provision to remove that later charge. But what you don't see is anything to deal with a situation where payment out of the company is taxable as a distribution in respect of shares, and then there is a relevant step taken by the trust. There's no provision that deals with that. And our submission is that's a good indicator the legislation doesn't contemplate that will be a situation that will arise. And that feeds into what we say about in connection with.
I think your submission is not that it doesn't contemplate that it would arise as a matter of fact, but that it's not intended to be caught by the Part 7A charge.
Yes, that's a better way of putting it. It doesn't envisage a situation where you've got a distribution in respect of shares that's not taxable as employment, and then Part 7A charge applies on what you do with that money. That's, yes. I now propose to move to taking you through 5 cases, some more briefly than others. The first case is on the application of Owen in the Supreme Court. The second case is Cobalt Data in the Supreme Court. Third is London Luton in the Court of Appeal. Fourth is Barclays in the Court of Appeal. And the fifth is Clipperton, both in the FTT and the Court of Appeal. And in my submission, there's 2 key propositions you can get from the cases we're about to review. The first is that in identifying the correct meaning of the legislation, the court should consider the background and relevant external materials shedding light on the mischief and purpose. And so this is partially a response to the Upper Tribunal saying it didn't derive much assistance from the background materials. The second key proposition is that the meaning of the words in connection with is heavily dependent upon context and purpose. And that second proposition is particularly important because it means this is not a case where Parliament has used an unambiguous phrase. means my argument is not an argument to cut back the ordinary meaning of an unambiguous phrase. Instead, we're engaging in the exercise required by the authorities to work out, well, what did Parliament mean in the first place? What did it intend to catch in the first place? So when my learned friend in his supplemental authorities bundle refers to Parker, talking about, well, we can't cut back the clear and unambiguous meaning of an anti-avoidance provision, I understand that, and that was Parker, but we've got here a phrase in connection with which is inherently requiring of the need for content. We need to look at the context and purpose, because inherently it could mean a spectrum of things. So we need to look at the purpose and context. We don't have an unambiguous phrase. The first case on the application of, I'm sure this court's been taken to it many times, so I will just show you, if I may, paragraphs 29 and 30. That's on page 727. And if the court is already so familiar with the propositions, it doesn't need to read them.
Don't worry, it's helpful to be reminded. But what I should just alert you to, Mr. Firth, thanks to Ghosh, is that when you take us to the authorities, certainly speaking for myself, I'm using the hard copy, but they're not tabulated, and it's not. It'd be helpful. Are you able to give me a volume number? I think 727 is in volume 2.
I'm afraid I'm not.
No, don't worry.
It is.
I can more or less. I think I know roughly where the divisions fall.
Yes.
But you may just have to bear with me when I get the right page.
I appreciate that, my lord.
727.
If it helps, it is volume 2 and it's tab 31.
Great.
Thank you much. Yeah. So paragraph 29.
Paragraphs 29 and 30, my lord.
Oh, right. Okay. Yeah. Is there anything specific you want to?
The proposition is a well-known one, that external aids are admissible. In explanatory notes, you can see, and this is paragraph 30, prepared on the authority of Parliament may cast light on the meaning of particular statutory provisions. And so when the Upper Tribunal says we don't derive much assistance from it, I'm inviting you to look carefully at that.
I don't think the Upper Tribunal was saying it's not admissible.
No.
They just didn't find it of particular assistance in this context.
So be it. I mean, all I'm doing is confirming, well, we should look at that, and we should look at the other admissible materials.
Yes.
And you can see it goes on to other sources. And so we do have other sources here, such as the Law Commission reports of board commissions and advisory committees, white papers may disclose the background to the statute and assist the court to identify not only the mischief which it addresses, but also the purpose of the legislation, thereby assisting a purpose of interpretation. And so where you have a phrase like in connection with whose meaning is heavily dependent upon background, context, and purpose, looking at the available materials, we say is a potentially very helpful exercise. And we say it is helpful here. It goes on, the context disclosed by such materials is relevant to assist the court to ascertain the meaning of the statute, whether or not there's ambiguity, and they reveal ambiguity. Then it goes on, but none of these external aids displays the meaning conveyed by the words of a statute that after consideration of the context are clear and unambiguous and which do not produce absurdity. We don't have that situation here. We haven't got a clear and unambiguous phrase. We've got a phrase that we need to give content to. The second case is the decision of the Supreme Court in Cobalt. That begins on page 889. I believe you said you didn't have tabs, my lord.
Yeah, that's in volume 3, I think.
Same volume.
Oh, not in mine, I'm afraid.
Volume 3.
Thank you.
889.
Yes, please, 889.
Yeah. Right.
The context, we can see at paragraph 1 on 889, this appeal concerns the conditions for the availability of 100% capital allowances under the EZA regime arising from expenditure incurred on the construction of buildings. You can see the relevant provision, section 298 of Capital Allowances Act. The purpose of this section, the time limit for expenditure on the construction of a building on a site is A, 10 years after the site was first included in the zone, and B, if the expenditure is incurred under a contract entered into within those 10 years, 20 years after the site was first included. And it's that part B, paragraph B, that concerns the Supreme Court, whether the expenditure in that case was incurred under a contract entered into within the first 10 years. We can see at subsection 3, paragraph 3, the issue is raised in that case because the contract in question entered into within the first 10 years gave rise to a range of options which the developer could choose from in terms of which one they wanted to take forward. And the question was, in that situation, once you make that choice after the first 10 years, is that expenditure under a contract entered into within the first 10 years? The point I would like to take you to is at 905, please.
905.
Yes, paragraph 70 sets out, again, well-known principles in relation to the interpretation of legislation. Emphasizing the importance of a purposive construction and paying close attention to the purpose.
Yes, there's the well-known passage in the Arrowtown case.
Yes.
The ultimate question is whether the relevant statutory provisions construed purposively were intended to apply to the transaction viewed realistically.
Yes, which is
You
well
would-
established.
yeah.
71. This is not, however, to downplay the importance of the language of the provision, as Lord Hodge said in on the application of O, which we've just seen. And then it says, that said, a phrase or passage must be read in the context of the section as a whole, in the wider context, and then it talks about the other sources. We've just seen that, so I won't trouble you with it again.
Yes.
But what is relevant is the approach taken to the question in that case by the Supreme Court. So at 77, the court says, well, both interpretations, we don't need to concern ourselves only with the detail of the interpretations, but both interpretations are possible interpretations. How do we decide between them? Well, we look at the purpose. And at 78, as to context, enterprise zones with their special features, including the availability of 100% capital allowances for expenditure on construction, were introduced in order to promote the regeneration of economically deprived areas. The regime was introduced in 1980 with the provisions for capital allowances, including the Finance Act. A Treasury press statement accompanying the budget statement in that year clearly set out the underlying purpose of the regime. And so what we see here is the Supreme Court going to the Treasury press statement to assist in understanding the purpose. It's quite a strong reliance on this because we see in 79, given the purpose of creating enterprise zones and conferring other advantages, it would be surprising if there were not a time limit. Such time limits are imposed. And then at the end of the first part of 79, you can see they refer back to the Treasury press statement. The Treasury press statement said this about the time limit. You can see that's picked up again at 83. Just below F, I'm sure the court's already seen it, below F on page 908, both from the terms of section 298 read in context and from the Treasury press statement, the purpose that clearly emerges is that construction of a building attracting 100% allowances should have occurred will be in the subject of a contractual commitment within the 10-year period. In this way, the aim of setting up an enterprise zone to achieve a significant impact will be realised. So the point I take you to this for is to simply show you the Supreme Court using the background materials in actually quite a strong way to establish what the purpose is.
And this is not even explanatory notes,
Not even
which
explanatory
have a
notes.
certain, it might be thought, have a certain formality.
Yes.
This is a press statement.
Treasury press statement, yes. And we've got budget statements which I refer to, which we say provide some assistance. The third case is the London looting case. I know my lady will be very familiar with this, but it's an important case, so I will show you in a little bit of detail.
Yes. Which page is this?
Tab 32.
Volume 3, I believe. No, volume
2, I think. I was looking at it earlier.
on page 739.
Sorry, page.
Sorry, page 75. Sorry, 746 is where I wanted to take you.
Yeah.
Should be
in my
volume 2 if this
It is volume 2, page 746.
Yes.
Yeah, I have that.
So this is the paragraph 10. We can see the provision that the court was considering in that case in relation to qualifying expenditure. So 360B. In this part, qualifying expenditure means capital expenditure incurred before the expiry date on or in connection with A, the conversion of a qualifying building into a qualifying premises, and so on. It's that in connection with that we see the court considering. If we could move forward to page 759, please.
Seven five nine.
Yes. Well, just to give you context, so you know where we are in the decision. On 758, the discussion begins, beginning with the authorities.
Yes, thank you.
And the court identifies a number of relevant authorities, and we've got at 62, the House of Lords and Coventry Waste.
Yes.
Can I ask you please just to read 62, including the quotation to yourself? We see by G, the House of Lords accepting that the phrase is a protean one, which tends to draw its meaning from the words which surround it. And the Court of Appeal itself says at 63 that Coventry Waste therefore stands for the proposition that the words will usually take their meaning from those which surround it in a wider context, and the courts and tribunals meant to determine whether the words have a broad or a narrow meaning understood in context. In literal terms, both meanings are possible.
But what is meant by both meanings there?
Both broad and the narrow.
Both broad
Oh,
and
I see.
narrow,
Both
yes.
in.
I see.
And that's what I mean when I say it's not helpful to talk about unambiguous terms in anti-avoidance legislation, because we have what is inherently a word or a phrase that's capable of more than one meaning. We need to attribute a meaning to it.
Well, don't we need to look at the first part of the passage quoted, where they were dealing with what the Court of Appeal had said, that it was a sufficient answer to construe the words in connection with as meaning having to do with. This explanation was adopted in an earlier authority, it may be that in some contexts, the substitution of the word having to do with will solve the entire problem. But I'm not, with respect, satisfied that it does so in this case, and Mr. Holgate didn't rely on this solution. So I just want to put the word protean in its context, which was that in that particular context, and that's how the relevant public authority, counsel for the valuation officer, was putting it.
I can obviously see that, my lord. The point that the House of Lords accept is, well, this is a protean phrase which draws its meaning from the words which surround it. And we'll see as we go through the Court of Appeal decision that they draw upon that, look at the context, look at the purpose, and attach a meaning to in connection with, in that case, which required a connection with the actual physical building works. So, I mean, I appreciate that it could mean that in some context. My submissions don't say it can't. My submissions are simply that, well, we need to look at what does it mean in this context.
Yes, well, that I understand.
And you can see.
But I think you get this bit circular after a while, doesn't it? Because you might say that whether it does just mean that or not is itself a question that's dependent on the context. You have to look at the surrounding words and
there's
everything
no
else.
avoiding.
Whether it does just mean it does mean to do with, or whether it's got a more nuanced meaning.
Yes, there's no avoiding looking at the context and background and purpose and trying to work out, well, what did Parliament have in mind here?
Yeah, well, it seems to me that's what the Supreme Court has made clear in O, although in fact it doesn't claim to be original. That's drawing on many decades, if I may say so, of the correct approach to statutory construction in this country, which is not necessarily accepted in all common law jurisdictions, actually. Some people do take a textual approach, for example, in other jurisdictions. But here, it's absolutely clear that the whole point, Lord Bingham said this in Quinta Vale, whenever Parliament enacts something, it does so with a purpose. And so you always construe legislation not according to a dictionary meaning, but having regard to its context and its purpose. Is that what it amounts
to? I'm
to?
not trying to bring you ground here, my lord, but this is a case on the meaning of in connection with, so that's why I do show it you, and why I will show you Barclays in a moment, because it is a fact, and you can see in the decisions that in connection with is given different meanings in different contexts, and based on the purpose and other factors. So that's I think what the point is being made at 62, the protean phrase, is it can mean a number of different things, or indicate a number of different things, and to work out what it means here, we go through the exercise my lord's just described.
Okay. So anything else in this judgment?
If we could then go to 64, there's a reference to Barclays Bank. I'm going to show you that case in a moment. But you can see in the middle it says it can describe a range of links. Lady Justice Arden referred at paragraph 19 to the need to examine the function or purpose of legislation to inform your thinking, which is no different to what's just been suggested. 69, the court summarises where it has got to. These cases show the meaning of on or in connection with is heavily dependent both on context and policy. It might require what Lord Justice Robert Walker referred to in Coventry Waste as a strong and close nexus, or it might require a weak and loose one. You can then see how the Court of Appeal approached the question before it at paragraph 70 onwards.
So can I just be clear, that's Coventry Waste in the Court of Appeal, is it?
Yes, because the House of Lords said, well, it could mean that, but we're not sure it does here.
Yes.
And at 70, the issue for this court is whether the disputed expenditure was incurred in connection with. At the top of 762, in determining the meaning of the words, there are 3 points which emerge from their context. First, the words in connection with are followed by a short list of the types of work with which the connection must exist in expenditure to qualify. And so here it's a connection with employment. And so that may inform the type of connection, the degree of connection Parliament had in mind. At 71, second, section 360b1 operates when qualifying building becomes, by a process of conversion or renovation, qualifying business premises. Again, at the end of 71 here too, the focus is on the physical subject matter, the converted premises. So again, the court is noting there's constant references, and what Parliament has in mind is physical activities. Third, at 72, the purpose of the legislation is plainly to encourage conversion and renovation of existing business premises to facilitate their return to use. The consultation document issued by the Revenue is not itself an aid to construction, but it is some general interest in understanding the broader context. Reference is made in that consultation document to the potential positive environmental impact. And then by F, in the regulatory impact issued in March 2005, the policy objective was recorded as being to increase private investment by bringing longer-term vacant properties back into use. 73, the purpose of those measures is to be taken from the legislative scheme as a whole, not require the premises actually to be used. Just above H, the purpose was therefore to encourage the conversion or renovation of disused properties to make them available for business use. So the court's noting repeatedly it's about physical acts. And at 74, we see where that leads us. In our judgment, these contextual features point towards the words in connection with being construed relatively narrowly. The connection must, by inference, be with a particular works of conversion, which leads to the building being at least available. Not necessarily that the used in fact availability and suitability are sufficient. And at 75, we test that conclusion by asking ourselves what the outcome would be if the opposite view were taken and a broad meaning were adopted. Two problems. First, that would open the door to an obvious risk of the use in avoidance, because it could be claimed, relief could be claimed even when the connection with works was tenuous. Second, it could lead to unfairness between taxpayers, because the position could differ fundamentally between cases where the property comes into use for the purpose of the taxpayer's own trade, and where it's let or available to a third party. Just by D, the desirability of construing tax legislation in a way that leads to fairness as between taxpayers was emphasised by Lord Wilberforce. He referred to an important principle in laws of taxation that in the absence of clear contrary direction, taxpayers in objectively similar situations should receive similar tax treatment.
Is that only a principle of construction in the tax context? Seems to me to be that the proposition might be a broader one, but I'm not sure I've come across it more broadly.
I haven't looked, my lord, but it would make sense that Parliament, well, it's an assumption of rationality, isn't it? If people are in essentially the same sort of situation, unless there's a reason to think they should be treated differently, it might be sensible to start with an assumption they're going to be treated in a similar way. But here we have it clearly stated in relation to tax. We say that is relevant, as you'll have seen from our skeleton argument, because an outright payment would only fall within 1C if it fell within the concept of reward or recognition in connection with employment. It would be strange, we suggest, if something that arguably is lesser, but definitely no more than an outright payment, were caught in circumstances where an actual outright payment wouldn't. So you've got reward, recognition, or loan in connection with employment. An outright payment can only be a recognition or reward, which suggests that the employment has to be part of the reason. It would be strange if lesser, or at least equal, benefits or transactions were caught by the loan limb, where employment was no part of the reason. That would be a strange, we suggest, outcome. But I'll come back to that later.
Right. Is there anything else in this judgment you'd like us
No,
to
my
see?
lord. We're now turning to the Barclays Bank decision, which I believe is in the same bundle, and it's page 759, please. Oh, in fact, that can't be right.
No.
Hold on a
That's
second.
2008, so I think it may be the earlier.
The dual
I think it's the earlier
266, so it must be the
volume 1.
first bundle, please.
Well, tab 19 219, is that the right? Have I got the right
Yes,
one?
my
Page
lady.
266.
Yes, it is. And it's on page 269 we find the beginning of Lady Justice Arden's decision.
Just bear with me. 269.
269.
Thank you very much. Yes.
And we can see in paragraph 1 the essential facts, which were that Barclays provided to pensioners and former employees free assistance in relation to their tax affairs, and that's referred to as the free tax service, not to be confused with a tax-free service. It was a concessionary benefit and was not regarded by Barclays of itself as taxable because it was paid in kind. But in 1997, Barclays decided to terminate this benefit and made a special one-off cash payment to compensate pensioners concerned with the loss of the benefit. And the issue on the appeal was the taxability of that payment for the loss of the benefit. Now you can see just by D at the end of the paragraph, for the purposes of the relevant definition, the payments are taxable if they constituted payments in connection with past service. You can see at paragraph 7, please, in the background, the pre-tax benefit was originally provided to the widows of pensioners alone, but the arrangement was extended to pensioners as well as their surviving spouses. Barclays conceded that the benefit was given in connection with past service. So the free tax service was in connection with employment. It was given to people because they were former employees. The question is, well, what's the taxability of the payment made to compensate the loss of that free tax service? If we go forward, please, to 765 at paragraph 18, you can see the discussion begins.
Paragraph 18.
Yes, my lord, on 272. I'm sorry, it's two different things.
That's all right. Oh, that's a very understandable mistake. Right.
Primary question is the proper meaning of the words in connection with. Expression could describe a range of links, reference to Coventry, which we've already seen. Paragraph 19, accordingly, the other part of the definition of relevant benefits and surrounding provisions will inform the court as to the extent of the link required. The court must examine the function or purpose of the definition of relevant benefits. Here, the purpose is to identify chargeable payments under a retirement benefit scheme. At the very least, Parliament's unlikely to have intended to limit this connection to direct connections. That would have left the possibility that taxpayers could easily circumvent the charging provisions. Furthermore, we must have foreseen that over the life of the scheme, it might change.
Can I just ask you to pause there a moment, Mr. Firth? I noticed that in this judgment, Lady Justice Arden, in this statutory context, said, as I understand, that it wouldn't have to be a direct connection.
Well, that sort of relates to the Upper Tribunal's decision on strong and direct,
Yes.
which of course neither party was arguing for. There might be a slight difference in meaning, because the indirect connection, as we'll see in Barclays Bank, was that the bank gave its employees or former employees the free tax service, and then and that was in connection with employment, and then it made a payment for taking away that service. And the Lady Justice Arden says, well, that was in connection with the payment and in connection with employment, and the reasons why you were chosen to receive the termination payment is because you received that which was in connection with employment, therefore the in connection with employment extends to the payment. So you can see the connection with employment there is through the free tax service to the payment, and I don't disagree with that in any way. The Upper Tribunal said strong and direct. I'm not sure if it meant to exclude that sort of chain of connections. I don't know. It's a very compressed piece of reasoning. It's not the argument I'm putting before you.
Right.
We can see that at 20. Thus, I conclude that a connection may be indirect, as in through the chain of connections, for the purposes of the definition of relevant benefit. Accordingly, it's possible that the making of the payment will have a relevant connection with more than one thing. In that situation, it is in my judgment necessary to see whether the connection can coexist or whether one will actually exclude the other. If on a proper analysis, the further connection displaces a prior connection, the prior connection ceases to be a relevant connection. And we see this idea of displacement again, and one of my submissions is the Upper Tribunal didn't consider whether the connection it thought it identified might have been displaced by, we say, the much stronger connection with the shares. Mr. Peacock's argument, he emphasised, this is 21, that although the recipients of the one-off payments were chosen because of their connection with the pension scheme, their status is simply one of the relevant surrounding circumstances. But in my judgment, once that status is shown, it is rare to find the connection is displaced. You will know from my skeleton, this is an area where I respectfully submit the Upper Tribunal went into error, because it's very clear in my submission at this point, Lady Justice Arden is saying that once you've shown that the reason for being chosen for a payment is the employment, or the former employment, it is rare to find that connection displaced. It is not saying that once you find any connection of any kind, it's rare for that connection to be displaced. This is specifically talking about a situation where the status is shown. It then talks about an example. If a company is in the practice of sending Christmas hampers to pensioners as a gesture of goodwill, there will be a connection between the hampers and past service. Recipients are chosen solely on the grounds of past service. In subsequent years, the company decides to substitute a cash payment. The cash payment takes the place of the hamper and therefore is connected to past service. So we see that in that concept of indirect connection there. But you had one thing that was in connection with, that now being substituted by another thing. That other thing is still in connection with, which we don't disagree with.
Right.
But we do say that paragraph 21 is placing heavy focus on the reasons for being chosen. You can see that just by G, the recipients are chosen on the grounds of past service. And so that would satisfy the test we say is the right test. Because in that situation, employment is part of the reason. And then 22, again, it's difficult to think of a case where a benefit made available to persons chosen for their connection with an occupational pension scheme is not given in connection with their service. You see again why I'm emphasising that this passage of paragraph 21, when it says that that type of connection is rarely going to be displaced, it's all about being chosen because of your employment or past employment. There's then an example of a cash prize where it might demonstrate that the connection is being displaced.
Yes.
And at the end of 22, on page 273, very end of the line, it demonstrates that once recipients have been chosen by their employer or trustee of the scheme for their connection with the scheme, the presence of that link is unlikely to be lost, and the court must give that factor. That is the criterion for selection. Those entitled great weight. So this is all about saying, well, it's very important why you were chosen, what the reasons for you being chosen were. And it's very clear in my submission that when Lady Justice Arden says in 21 and 22, that's unlikely to displace, she's talking about that type of connection. She's not talking about, and doesn't have in mind, other looser forms of connection you might identify. It's all about, well, if you are selected, and employment's part of the reason for selecting you, then that's unlikely to displace, which we don't disagree with. At 23, the definition of relevant benefits is not, however, unbounded. There must be a link with service. In my judgment, the expression give is important. In this respect, I differ from the judgment of the judge. The word creates a requirement for the maker of the payment to have known the facts constituting the link with the past service. It does not, however, assist Mr. Peacock's argument, because it does not entail any subjective requirement on the part of the maker of the payment for the payment to be linked with the reward for service. So that simply means that if the pre-tax service is in connection with employment, and you decide to make a payment in substitution for that, the fact that you might not have had in mind the reasons why they got that free tax service in the first place doesn't stop the second payment being indirectly connected with. (24) The Special Commissioner thought it was necessary to find the payment was in fact a deferred reward. In my judgment, this imposed a gloss. The gloss was unjustified because the expressions pension and gratuity do not entail any necessary element of reward. And so the expression other like payment cannot do so either. 25. Mr. Peacock's submission is that the one-off payments were strictly compensation for the free tax service and not in substitution for it. The one-off payments certainly served a different function from the pre-tax service, and in that sense they were not in substitution. However, nothing turns on this point, because the expression in connection with past service covers payments that are indirectly connected. And then at 26, Lady Justice Arden returns to the facts. I agree with Mr. Peacock that all the relevant circumstances must be taken into account. It does not mean that all facts must be given the same weight. In this case, the class of recipients was limited to those who'd been employees or had a connection through an employee. No one else could come within the class. So what Lady Justice Arden's, again, talking about the reasons why you're chosen. As I've said, the criterion for selection of recipients is a strong factor, to which, in my judgment, substantial weight should be given. The other facts emphasized by Mr. Peacock, such as the calculation of the one-off payment, by reference to the age of the recipient and the complexity of their tax affairs, are subsidiary matters which are secondary to the selection of the class. In my judgment, the judge was right to say there was a connection here between past service and giving the payments. The free tax service had clearly been provided because the pensioners were former employees. That link continued through the paying of compensation. The reason for paying compensation was to compensate them for the loss. Once that added element that the payment had to form a reward of past service is discounted and removed, an overall assessment, far from supporting Mr. Peacock's case, is against it. You can see, ultimately, what Lady Justice Arden is relying on here is, well, employment is part of the reason. And once you've got that, in that case, it was part of the reason for selection. Once you've got that link, it's a strong fact and it's unlikely to be displaced. And it wasn't displaced in the facts of that case.
But it doesn't suggest that she's saying this is a requirement of law as a matter of statutory interpretation. What she appears to be saying is that the criterion for selection is a strong factor to which substantial weight should be given, which suggests that the statutory test is the statutory test, whereas it might be said that on your submission you're asking the court to substitute a different form of words for the statutory test.
Well, we have to give content to the meaning in connection with, and that requires us to examine what types of connection Parliament had in mind. In my case, it's twofold. And the positive case is that we can, looking at all the background materials I'm going to come to and the context and the purpose, that those will provide strong indicators that Parliament is looking at situations where employment is part of the reason. So that's the positive case. The negative case is the absence of any explanation for why other types of connection should mean that you find it is in connection with employment for this purpose, so as to lead to a charge in employment tax. So necessarily in that situation, you're dealing with a situation where employment is no part of the reason for the payment, but nevertheless you're saying it should be taxed under Part 7A. Can we identify anything in the background, context, or purpose to suggest why that should be so? And that's how I set my case up. So it's not rewriting the legislation. Legislation inherently requires us to examine what types of connection. And as I said, I've got two aspects of that. The positive case, here's all the reasons why it should be part of the reason, or part of the reason it's required. Actually, the complete absence of any justification for the alternative. I mean, that is one of my points, which is that how can you be avoiding employment tax if employment is not part of the reason for the payment? Yes. But it is interesting that in my submission, even when Mr. Peacock is making his submissions are directed at trying to find another reason for the payment. He's saying, well, look at the way it's calculated. It's calculated by reference to the value of the benefit to the recipient. He's trying to suggest an alternative reason for the payment as opposed to the past connection with employment. And so nobody's actually looking at a type of connection that doesn't go to the reason for the payment. In my submission, when you read 25 and 26 together, they're both directed at what are the reasons for the payment. And Lady Justice Arden says, well, we can quite clearly see that the criterion for selection was employment, and that's a strong factor that, in this case, answers the question. So that, again, that what you don't see in 25 or 26 is any explanation, justification, or support for other types of connection, whatever they may be. They've never been identified, but other types of connection being sufficient for employment tax purposes. The final case I wanted to show you is Clipperton. This is a case that HMRC rely upon. It's at paragraph 21, subparagraph J of their skeleton argument. And in fact, they put in a supplemental authorities bundle with the FTT decision in.
Right, so where are
Go
we
to the
going?
supplemental authorities bundle that HMRC provided, please. And it's the second case. My version begins at page 43. No,
35, yeah?
sorry, it's at page 43 of.
I'm doing it slightly different way.
Oh, wait, I apologise. I've got an electronic version and it's at page 43 in the bottom right, but it's
Oh, sorry, what are we on Clipperton?
Clipperton
Yeah.
First Tier Tribunal.
I
not-
see,
not
okay,
Court.
and that's where?
HMRC provided a supplemental authorities bundle in
Ah,
hard copy.
yes, there, I see it here.
Do you have that?
Yes, Clipperton, I'm there. I'm sorry it's taken me a while, but I have got that.
That's one.
And for context, this is the decision of Judge Morgan. So
Yes.
Judge Morgan decided our case, she decided this case, and in fact she decided them in fairly quick succession. They were on foot at the same time. So you can see this decision is 20th of January 2021. I believe our decision was September 2021. So Judge Morgan decided both of these cases. We can see the facts are summarised in terms of what scheme this was considering at paragraph 1 on page 47.
Yes.
So we've got a HMRC decision that sums which they received from an arrangement set up by a company, Wynn & Co. in Yorkshire, of which they were the sole directors and shareholders. That's important. Were subject to income tax in 1112. Again, so this is a situation where Part 7A is in force, and we've got sole director shareholders receiving payments, which we will see came from a trust that received payments from a company. It was not disputed that the arrangements were put in place for the sole purpose of enabling Wynn Yorkshire to put sums into the hands of the appellants as its shareholders without attracting the income tax charge which would usually apply if they'd paid a dividend. Well, that is the same as our facts on the FTT's findings. The point the FTT found, well, the purpose and the reason for this payment was to provide money to Dr. Thomas in his capacity as a shareholder. At 2, we can see the basic scheme. 1, Wynn Yorkshire subscribed for shares in a newly set up subsidiary, Scarborough. There's 2 shares, A share and B share. Step 2 is that Wynn Yorkshire settled the B share on trust, largely for the benefit of the appellants, but on the basis that it was entitled to a small amount of the money with the income arising. So we've got Wynn Yorkshire setting up a new subsidiary, A share, B share. The B share is then settled into a trust for the benefit of the shareholders of Yorkshire, with a slight benefit to Yorkshire itself. That was intended to engage the settlements legislation. 3, Wynn Yorkshire then subscribed for a further A share for £200,000. 4, Scarborough's share capital was reduced by £200,000 by cancellation of the share premium, and the amount was credited to distributable reserves. And then 5, it declares a dividend on the B shares. So the money goes from Yorkshire into the subsidiary out to the trust, and then we see in step 6, the trust pays the money to the shareholders. So in a roundabout way, the money has gone from Yorkshire to the shareholders. And we see that the Court of Appeal, well, in fact, Judge Morgan says, well, that's just a distribution to the shareholders, and the Court of Appeal agrees. If we could go forward to paragraph 16, please, on page 52. From the facts set out above, and in particular the stated purpose of the planning in the letter sent to Wynn Yorkshire, I find that the sole purpose of the relevant parties in implementing the arrangements described was to enable Wynn Yorkshire to provide its shareholders with the funds they received as a return on their investment in shares in Wynn Yorkshire, without attracting the income tax charge. It usually applies to dividends or distributions. I did not understand the appellants to dispute that. And that's very similar to the finding we've had in terms of, on the evidence, what was the reason for this payment, while it was to provide a return to the shareholder. We could then skip forward, please, to page 84. paragraph 127. I'm taking this very short because we'll look at the Court of Appeal in a moment.
Yes.
But you can see Judge Morgan's conclusion. In other words, viewed in their entirety, the purpose and effect of the arrangements was to enable the appellant to receive the bulk of the £200,000 which Win Yorkshire used to subscribe for an additional A share as a return on their shares in Win Yorkshire. The fact that the appellant's shareholders did not receive the sum is correct, but through a series of steps designed solely with the intention that they would not be subject to income tax on the sums does not detract from the nature of the receipt in their hands. So just to summarise where we've got to, we've got a company with shareholders. There's a scheme involving a trust and a payment to a trust, and then the money goes from the trust to the shareholders. And the first tier tribunal is saying, well, that looked at realistically in substance as a distribution to the shareholders. It's taxable as such. I know that that's exactly the same, or very similar to what we've got in our case. We've got Dr. Thomas, shareholder of the appellant, and the tribunal's findings are that the reason for this was to get the money to him in his capacity as a shareholder. And we say that provides, well, that confirms and supports the idea that this is in substance, in reality it's a distribution. And if it's notable on HMRC's interpretation, and indeed the Upper Tribunal's interpretation, logically this should have been dealt with under Part 7A. But it wasn't. Because the breadth, and that is the consequence of the breadth of their interpretations, that it seems on the Upper Tribunal's interpretation, well, if you're a director of a company and that company makes money, what is done with that money is necessarily in connection with your employment and can be within Part 7A, but we say that's too broad. The Court of Appeal upheld that decision. If we could go please to the main authorities bundle. Page 830, which is going to be, I think it's volume 2.
$820.
830, my lord, is the
Yeah,
relevant passage.
I think it starts at 820.
Yes, yes.
And 830 is where you want us to go.
Yes, and it's paragraph 29, please.
Thank you.
We see there, if one considers the scheme as a whole, then there is little doubt that Judge Morgan and the FTT was entirely justified in her conclusion.
Sorry, I've lost my place. Where do I go?
Paragraph 29, page 830, my lady. So, second sentence, the payment by Win Yorkshire to Win Scarborough was simply the first step in a scheme designed to distribute the majority of the money to the appellants. The money was being distributed to them because they were the owners of Win Yorkshire and wished to extract profits from the company into their own pockets. Everything else was just a means of enabling that to happen. This is clear from the factual findings of Judge Morgan, not challenged in this appeal, that the sole purpose in implementing the arrangements was to enable Yorkshire to provide the shareholders with the funds they received as a return on their investment. In those circumstances, the conclusion that the money they ended up with was a distribution from Yorkshire out of its assets to the appellants as holders of the shares seems to be not only one that was open, but obviously right. And we would say, well, if it's obviously right, then in those types of situations the money is taxable as a distribution in respect of shares, we respectfully submit that it can't be, shouldn't be taxable as employment income, and employment can't be part of the essence. So my lady made the point earlier about we're looking at the substance here. Well, the Court of Appeal has looked at the substance of very similar type of, in the end, a similar type of arrangement where you're going through a number of steps to get money to the shareholder in their capacity as shareholder. And so what's clear, it's obviously correct to say, well, this is all about a distribution in respect of shares. And we say, well, if that's right, that is the substance. That tells you the essence. At 31, it follows that the answer to the first stage of the inquiry is that the distribution in respect of shares is on a purpose of construction wide enough to include a distribution by a company which is designed to reach and does reach the company's shareholders even if it does so as a result of a series of steps. That is the class of facts intended to be affected by the charge. The second stage of the inquiry is to discover whether the relevant facts fall within that class in the sense of the answer to the statutory description. This is straightforward enough. That distribution by Yorkshire was, as to some 98.5%, designed to reach and did reach the appellants. It therefore answers the statutory description. Well, given that, as I said, that is the essence, that is the substance. Employment is not part of the substance, even though these are sole director shareholders. And it's very difficult to see why that should be the case, given the double taxation it leads to.
Can I just check my bearings, please? There's no question in this case, was there, of Part 7A, nobody was arguing.
Nobody raised
Section
it, as far as I can see.
554, nobody was looking at that at all. It was a completely different question about whether these receipts by the shareholders should be taxed as income or not. That was what they were.
Whether they should be taxed as distribute. The scheme was to say, well, the actual distribution is made to the trust.
Yes.
The trust is a settler interested trust, therefore we treat the income as income of the company alone. It wouldn't be taxable, and therefore that is the tax result. There's no tax on the payment out by the trust. That was
This tax avoidance scheme failed
yeah,
because the shareholders ended up having to pay tax on what they received.
yes.
But nobody was looking in the direction we're looking at.
No, there are various references to the earnings case law in the FTT, but absolutely, I agree. Part 7A wasn't raised as a consideration. I agree.
And Mr. Firth, can we just be clear what the statutory language was, which was being construed and applied in that case? I think we find it at page 830, where between letters F and G, Justice Newgee quotes the statutory language, I think. Any other distribution in respect of shares in the company.
Yes, and that's my point. Is we had the same finding in our case, and the court doesn't just say, well, that's. Bearing in mind, the court is all times here looking at the substance. It's trying to just derive the substance of the arrangement, and it says not only was George Morgan correct, but she was obviously right that the substance of this is about distributions in respect of shares. So I accept it's not looking at Part 7A, but it's odd at the very least that if HMRC are right in their arguments in this appeal, this should all have been taxed under Part 7A as well, in fact, or at least instead of.
So as well, or only under Part 7A?
Well, there's nothing, that's my point, is there's nothing to exclude the charge on the distribution, although we'll come in a moment to what the Court of Appeal said about the distributions in that case, because the Court of Appeal, there was the question of what happens to the company. Is the company also potentially liable to tax? Has it received a distribution? We'll come to that in a moment. But as I've shown you when we went through the legislation, there is nothing that excludes tax on a distribution by reference to a later relevant step, or it could be at the same time. But the relevant step has its own tax charge, and the contribution to the trust has its own tax charge. But if we follow that through, please, to page 838 in paragraph 64, you can see my submission on this is that it helps you understand the essence of what the scheme, what the arrangement was about, because you can see the Court of Appeal considering that question. In fact, HMRC is submitting on it. So at 64, this is dealing with, well, what's the position of the company in respect of its distribution. Ms. Poots said that there was two possible answers. The first is that there was indeed only one distribution, namely the Wynn Yorkshire distribution. This was because in a case where Ramsey approached least a composite transaction being taxed as one overall transaction, the individual elements of the overall transaction are just mechanics and are subsumed into the overall transaction. They have no separate existence for fiscal purposes. I think this argument is well founded. See UBS, Lord Reed, where he refers to schemes that involve intermediate transactions inserted for the sole purpose of tax avoidance, and says it's quite likely that purpose of interpretation will result in such steps being disregarded for fiscal purposes. If that is right, the Wynn Scarborough dividend had no separate existence for tax purposes, not to be viewed in isolation, but simply as part of the means by which Yorkshire distributed to the recipients. And again, what I'm using this case for is to help with the essence, the substance.
Are you relying on it for a second reason, which is your double taxation point?
It does illustrate that, yes.
If the essence of what's happened in our case is materially the same as happened in this case, your submission is that is properly to be regarded as a distribution in respect of shares.
Yes.
And not, for example, employment income.
Yes.
If you arrive at the contrary conclusion, as the Upper Tribunal did in our case, not only, I think your submission is, not only does that give no effect to the essence of the transaction, but also it gives rise to a double taxation problem.
That's it, yes. And I've already shown you that there's nothing in the legislation, nor in the principles in the case law, that would remove that. Because yes, the principles of the case law says, well, you can't have two tax charges on the same event, so the relevant step. That's not what's happening on the Upper Tribunal's analysis. And I've shown you in the Z 2, 3, 4, 5, 6, nothing covers this situation. So yes, that is my submission. Unless there are any questions on the cases I've shown you, I now propose to take you through the submissions in my skeleton argument in relation to the grounds of appeal.
Thank you. And just to be clear, are you dealing with grounds 1 to 3?
1 to 4, my lord, and then
1 to 4.
ground 5 is the corporation tax issue, which Mr.
Very
Bates
good.
will address.
Very good, thank you.
If I may take the court, please, to paragraph 21, that sets out our interpretation, which is the same as the FTT's interpretation. And then at 22, I summarize the reasons which I'm about to take you through in terms of why we say that is the correct approach. I begin, if I may, with the purpose at which Part 7A was directed. I've already shown you, as I referred to at 23, on the application of the Supreme Court. If I may show you the explanatory notes. So that's page 184 in your authorities bundle, which should be volume 1.
Sorry, can I just have the page number again?
184, my lord. And it's paragraph 271 at the end, background note. The June 2010 budget announced that legislation would be introduced from April 2011 to tackle arrangements using trusts and other vehicles to reward employees which seek to avoid, defer, or reduce tax liabilities. So you can see there, it's to tackle arrangements. This is the background anyway. To tackle arrangements to reward employees, which using other vehicles to reward employees which seek to avoid, defer, or reduce tax liabilities. And that's a key theme of what I'm submitting, is that the concern of Parliament in enacting Part 7A was not that the tests in the general earnings legislation was insufficient to say, well, that is from employment. It was concerned that for some reason, because it was paid to a third party, that didn't result in taxation of employment. And you can see that is given effect and recognised here. To tackle the concern is, well, for some reason, if you use a third party, we might not be caught. We're going to deal with that. You see that reference to rewarding employees and also avoiding tax. I mean, as I've made the point, if employment is not part of the reason for the payment, it's difficult to see how you can be avoiding employment tax. As here, if it's accepted, if this Dr. Thomas had just paid himself a dividend instead, there'd be no question of employment tax. It's very difficult to see how those sorts of arrangements could be said to involve any avoidance of employment tax. Now, I accept, and I said before, that is not a criteria in 554A. The HMRC don't need to prove, or it's not relevant to the statutory test to say avoiding employment tax was part of the purpose. That's not a criteria. But necessarily when we're looking at the meaning of in connection with, and it is suggested, as it is, well, this is a broad spectrum anti-avoidance rule to stop people avoiding employment tax. But it's relevant to consider in what way you can be avoiding employment tax if employment is not part of the reason for the penalty. You see there the reference to the budget announcements. If we go, please, I assume this is going to be bundle 3. Yes, it is bundle 3, please. It's page 1035.
Yes, thank you.
Now, paragraph 5.62 at the bottom of the page. HMRC has used its Spotlight publications, we're going to look at Spotlight in a moment, to make taxpayers and their agents aware of the risk of taking up tax avoidance schemes. It will continue to use litigation as a tool to tackle tax avoidance, and has recently been successful in the areas of residence and the use of arrangements to reward employees through intermediaries to avoid tax. So there, we see this reference to use of arrangements to reward employees through intermediaries to avoid tax. In addition, HMRC is strengthening its focus in high net worth units. And at 5.63, Budget 2010 announces action on ... Fifth line, middle of fourth line. The government also announces future action to tackle the use of arrangements to reward employees through the use of trust or other intermediaries with the purpose of avoiding, deferring, or reducing liabilities to income tax and NICs, or avoiding restrictions on pensions relief. The government will consider options for tackling these avoidance arrangements with the intention of introducing legislation in April 2011.
Yeah, was this the first budget of 2010? I think
Yes,
that-
we've got the June
yeah.
budget in a moment,
Yeah.
which makes it
right.
going to take.
Was that because there was a change of government that year?
Yes, wasn't that the year that we went from Labour to Conservatives, Lib Dem?
Precisely, yeah.
Yes. But you can see there again, it's the same theme, the same mischief, and ultimately the same purpose of preventing avoidance of employment tax through rewarding employees via intermediaries.
Yeah. Is your fundamental submission in this context that consistently and throughout the background materials, we see reference being made to the use of arrangements, quote, to reward employees?
And to avoid employment tax.
Yes.
It's the 2 points. And that's why I say I've got my positive case, which is this is all good background material to support my interpretation that says if employment's part of the reason, is in connection with it. But also, it's my negative submission, the absence of any justification, explanation, or reason why if employment's not part of the reason, nevertheless, this piece of legislation developed and crafted in this way for these reasons should apply to it. I mean, you can think of situations where there's one problem, but Parliament decides to take a broader approach and shut down an area. But it's very difficult to see why that should be the case here. If employment's not part of the reason, why should it be caught by legislation giving effect to this mischief background purpose? That's the negative side of it. As you referred to, my lord, there was a second budget, and we can see that on 1247.
Right.
Paragraph 2.167. March 2010 budget announced action to tackle arrangements using trusts and other vehicles to reward employees which seek to avoid, defer, or reduce liabilities of employees and directors to income tax and ISCs. Before restrictions on pension relief will take effect from April 2011. So it's the same thing that's continued through.
So the point is that although there had been a change of government, there had been no change, you submit, as to what the envisaged purpose was of the forthcoming primary legislation, which was duly enacted in 2011,
Correct.
and is the amendment that we're concerned with.
Correct. We've seen the March 2010 version. We've got the June 2010 version, and you saw at the beginning the explanatory notes themselves. It's a consistent theme throughout. So it would take some explanation and justification in my submission to say, well, it covers payments where employment's no part of the reason, because I don't detect any justification for catching payments where employment's no part of the reason in these background materials. And therefore we're taxing things as employment income. We can't explain why. We can't explain why Parliament would have intended to catch this as employment income. That's a puzzle in my submission. You can also see the nature of the problem that HMRC and we would submit by inference Parliament had in mind in the Spotlight. In Spotlight 5, it's page 1302 from August 2010.
Sorry, just go a bit more slowly if you would. Spotlight 5, and it's page...
1302, my lord.
Thank you very much.
Well, the beginning is on page 1300. PAY,
Oh, yes.
NIC's contributions, corporation tax and inheritance tax using trusts and similar entities to reward employees. Spotlight 5, August 2010. So that's the context.
Right.
And you can see on this is helpful, not because we say the legislation should be restricted to arrangements that fulfill any strict criteria set out here, but because it tells you the mischief. What's the problem? Or helps you identify the mischief. What's the problem that Parliament believes exists that it needs to address? And we can discern that by looking at the problems HMRC were encountering in relation to this type of arrangement at the time. And you can see on page 1302, in the second paragraph, HMRC are aware that companies have been seeking to reward employees without operating PAYE or NICs. This is done by making payments through trusts and other intermediaries that favour the employee or their families. The arrangements usually seek to secure a corporation tax deduction as if the amounts were earnings at the time they are allocated. They also defer PAYE and NICs or avoid them altogether. HMRC believe that at the time the funds are allocated to the employee or the beneficiaries, those funds become earnings on which PAYE and NICs are due and should be accounted for by the employer. Pause there. At this time, HMRC are not saying and do not believe that the payment into the trust is the earnings. They believe, as you can see in that paragraph I just read, is the point at which the trust allocates the funds to the employee. That's when the tax charge bites. And that's what they were arguing for, we'll see in the Rangers case, at the first tier tribunal level and the upper tribunal level. That's what they were arguing for. It's in this Court of Session in 2015 that HMRC switched to saying, well, we don't want to tax now the allocation to the employees, we want to tax the actual payment into the trust. And that happens in 2015, 5 years later. So you can see why Parliament, assessing the lay of the land, would have thought, we've got a problem here, because these payments into the trust are not taxable as employment income. HMRC are trying to tax the allocation within the trusts, all these other arrangements. And that's what you see then Part 7A does. It then says, puts beyond doubt, gives rise to Part 7A charge, and exactly that, the earmarking or the relevant step. But Parliament doesn't believe that the payment into the trust is taxable as earnings. You can see that there.
Now, is there any authority which says that this is admissible for the interpretation?
The way I'm using this is not as a direct aid to the interpretation. This is to help you understand the context in which Parliament was legislating. So if you've got a context in which lots of people are putting forward arguments as to why this arrangement or this type of arrangement doesn't give rise to tax, that might help you understand what Parliament was attacking. Put one way, if we arrive at an interpretation which didn't deal with this arrangement, something's gone wrong. Because Parliament very clearly had this type of problem in mind. I am not saying it's limited to this. I'm not saying that. But this helps, this problem that Parliament, we've seen in the budget documents, was trying to address, does help understand what Parliament had in mind. And you can see at the bottom it says HMRC are actively challenging examples and considering legislative options to end further use of these schemes.
But that suggests challenging, for example, in a tribunal.
Which is the Murray Holdings case,
Yes.
the Rangers case we're about to come to. But I know the time, my lord, and
Yes.
I don't think I would want to take you through the
No.
various stages in one go. So
No. Well, can I just ask you how you're doing for time generally?
I think I'm doing fine, my lord. I've done a lot of heavy lifting as I've gone through.
Yes, I thought so. Well, on that basis, I think it would be sensible for us, rather than embarking on the Rangers case now, why don't we do that at 2 o'clock?
Yes, my lord.
All right, enabled.